Hello everybody, welcome back to Law Hero. If you haven't been here before, my name is Jen and I run this channel and I normally talk about legal stuff and some performance psychology and other things like that, which are all relevant to your life as a lawyer. And I focus a lot on the FE1 exam in particular because I know a lot of people come here for that, but I hope you stay longer than that, you stay subscribed, because yeah, I like to think that my channel will follow a trajectory. So for example, if you are finished with your FE1, let's start at the start. If you're a law student and you come here, that you'll find some information. When you're an FE1 student, you'll find some information, and then when you're training to be a solicitor, you come here and find some information too. So what I'm just saying today, for example, in this company law video, is not only applicable to FE1 students, because if you're a trainee solicitor or even if you're a junior lawyer, this kind of stuff is very important when you're even advising clients. Like even for me, for example, to know this as an in-house lawyer is very, very important. Okay, so you may have seen on Instagram that I was in town, Dublin. If I was in Cork, I would call Cork town. That just goes to show you. And I was on Henry Street and I could see there was a lot of premises that had shut down. A lot of companies are after going into liquidation because of COVID. Obviously, because the cash flow isn't there, they cannot pay their debts as they fall due, and that's how you become insolvent. So thankfully, the company's miscellaneous provisions bracket Covid-19 Act 2020 was signed into law, I think last month, just before they wrapped up for the summer. And I'm just going to go through some of the main points from that law, because it's not only relevant for FE1 students who are sitting their exam this autumn time 2020, but it's also important for practitioners and trainee solicitors who are interacting with companies. For example, if you're on a corporate rotation as a trainee. Okay, so the first issue we're going to look at are general meetings, so AGMs and EGMs of a company. So obviously, because we're all working from home, and the usual requirement to have an AGM or an EGM is difficult, and I've actually experienced this myself. I sit on a few boards and they've all been held virtually, but at the very start of COVID, we'll say kind of like March time, if you were due to have an EGM or an AGM, a lot of people were very kind of confused. They were afraid that they would breach their company law obligations, because when you look at the Companies Act, it actually doesn't say explicitly that you can have, that you can have a meeting held virtually. So a lot of people were wondering, oh, if we have it virtually, are we in breach of the Act? And you're actually not in breach of the Act. So that is one very, very handy thing. So the first point I want to make is that a company actually may postpone its AGM up until the 31st of December 2020, and this is when the interim period, which I spoke of, runs out. Okay. The second thing is that general meetings may be conducted as fully electronic or virtual, provided those entitled to attend have a reasonable opportunity to participate. And then the date, location and means of holding an AGM may be changed by giving notice up until any time up until the end of the day prior to the day scheduled for the meeting. And all of this simply just means that there is more flexibility and more kind of accepted flexibility around AGMs and EGMs, whereas before it was a little bit of a grey area as to could they be held in a non-physical location. That's now been clarified by this law, which is great, and hopefully all of this will continue after COVID, well, if COVID ever goes away. Now, the second big area is dividends. So as we know, dividend is simply the payout a shareholder gets from being a subscriber to a share, and basically it's the whole point of being a shareholder. You want to receive a dividend, and obviously dividends depends on the trading performance of a company, and as I said, a lot of companies, particularly retail from what I could see this morning, and of course because of the commercial leases in Dublin, are suffering. Their trading income is suffering. And so now this act recommends that the declaration of a dividend before the impact or potential impact of the pandemic on the company was known. So we'll say if so the difficulty was with the current scenario with the pandemic was that directors might have declared a dividend before the pandemic actually rolled out. So now where directors form the opinion that due to the actual or perceived consequences of COVID-19 on the affairs of the company, the dividend should be cancelled or reduced. And actually this is interesting because the European Central Bank, the ECB, have also done the same in my industry, which is banking. They have told banks to withhold their dividends until October 2020, which is obviously a massive blow to shareholders of banks, simply because of the pandemic we're in. So they may withdraw the resolution to approve the dividend or propose an amendment to the resolution to provide for a reduced dividend. Is around execution of documents, and this was everybody's big worry at the start of COVID. How are we going to get documents sealed? How are we going to get documents signed if nobody is physically present? But you know what? From what I can see, witnessing, like I've heard stories of solicitors come to the window and that's them witnessing the document being signed for statutory declarations and sworn documents. I've heard that from some of my friends. I think it's wonderful to see that it's working. And again, I think it's a surprise from the pandemic, and yeah, we'll see how this continues. But anyway, so normally, as I said, you need a signature of 2 directors for when a company is signing up to an agreement, or a director and a secretary. But obviously this is difficult. So the Act says that during the interim period, a company seal and the necessary signatures may be executed in counterparts. Now, normally you would have a counterparts clause if you were clever, but this is just kind of like a mandatory allowance for that, as separate documents and then counted as one for the purposes of the Companies Act 2014. And I guess this is for people who are lodging stuff in the CRO area, is liquidation. And don't forget, like I always say to my trainees, liquidation comes from the word liquidity, and liquidity means cash flow. Cash flow and being solvent means you can pay your debts as they fall due. And obviously cash flow has been a big problem for companies during COVID. So normally the demand was a threshold of 10 grand. So if you owed 10 grand or more, you were in danger of receiving this 21-day letter. But now the threshold has gone up to 50,000 during the interim period, which is great. So that gives companies a bit of breathing space that they won't be wound up by their creditors during COVID. But again, as I said, this only runs till December, so we'll see what the crack is. Now, my friends, if you're a FE1 listener, you know that sometimes I give tips and tricks for the exam. I reckon examinership might be asked this autumn simply due to frequency of topics on the exam. I think you might ask examinership this autumn. And also examinership is the final area which comes into question under the 2020 Act. So because we are in a pandemic, and if you're an examiner and you're trying to get value for money, or you're trying to maintain the business as a going concern, this might be very, very difficult for you. So what the Act has said, that where there are exceptional circumstances, an examiner may apply to the court to extend the period of protection from creditors up to 150 days from the current 100-day period. Again, it's another leeway for companies. This 50-day extension may only be sought where the examiner has already obtained an order extending the 70 days, because as we know, examinership is 70 days. Exceptional circumstances is COVID-19. Okay, so that's it. I think if you throw in this Company Law Miscellaneous Provisions Act 2020 into your FE1, or even if you update your clients on this, I think you'll be doing very, very well, and it'll show that you're in the know and that you care about company law like I do. So yeah, I'm gonna make more videos like this one. I quite enjoy it myself. It's good for me to cement stuff into my head too. So it's not completely selfless. And yeah, please make sure you like and subscribe. I really enjoy making these videos. I hope you enjoy listening to them. And yeah, I think we're in this COVID thing for the long haul. I think I'm going to be in this house for a very long time. I don't think I'm going to be back in my office for a very long time. I don't think you guys are either, unless something happens, you know, in the meantime. So yeah, stay safe, mind yourself, and I'll see you in the next one.